Welcome, everyone. Let's convene. We're convening just a few minutes late to allow people to trickle in. Welcome. I'm Chris Hufnagel. I'm a professor at the School of Law and one of the faculty directors at the Berkeley Center for Law and Technology. And on behalf of the Berkeley Center for Law and Technology and my colleague, Paul Schwartz, I warmly, well, Paul's in the back here, warmly welcome you to the second annual cybersecurity lecture that BCLT has hosted. Want to give a special thanks to our staff who expertly put this together. Abril's in the back, so is Alexis, I see Justin, and of course Richard Fisk. Thank you for all the attention to detail in making this happen. It's an honor to be able to host my old friend Nico van Eijk back at Berkeley. We haven't been able to talk for a few years, and he's going to explain why. Nico van Eijk has had a distinguished career as lawyer, academic, and public servant. He's a graduate of the University of Tilburg, where he earned his law degree, and the University of Amsterdam, where he earned his PhD. After that, he practiced as a telecommunications lawyer in Europe, and then returned to the University of Amsterdam as a professor of information and telecommunications law. He ran the excellent center there, EVIR. Some of you probably know that EVIR, the Institute for Information Law, right, has a great relationship with Berkeley, and many of our faculty have spent time teaching at EVIR, and conversely, EVIR faculty have come to Berkeley to share their insights with our students. So he came back to the University of Amsterdam in 2004. He then directed the Institute for Information Law, and in 2019, this is where it gets really interesting, he left academia to become the chair of the Review Committee on Intelligence and Security Services of the Netherlands. He recently left that position, and today he's going to share his leadership learnings on oversight of security services. Professor Van Eijk is going to speak for about 25 minutes, and then I will facilitate a Q&A, and of course, we invite all of you to participate by asking questions. And after that, we'll have a nice reception out on our sunny deck here. Welcome, Professor Van Eijk.
Good afternoon, or good night if you're in the Netherlands. And Chris mentioned a lot of the activities I did. I also was involved in merger and acquisitions for quite some time, and if we were trying to sell something to, let's say, American funds, we would always organize the meetings in the afternoon, because that's when you start to suffer from your jet lag. First of all, Chris, Paul, thanks again for inviting me. I feel really honored. I've been to Berkeley several times, but it's every time a pleasure to be here. And that's not just because the weather is great today. So thank you so much. I will speak, and I will do that from paper. And the only reason is because the last 5 years, I was in a position where you see a lot, hear a lot, and you need sometimes to be a bit careful about how you formulate things. And as this session is going to be recorded, I want to be sure that I've not said things that I am not supposed to say. This sounds more important than it is. It's also a great help to keep things structured. So the website of this lecture starts with a statement that cyber represents one of the biggest challenges to national security and to the protection of fundamental rights. And allow me to give you a few challenges that I've been meeting in my previous employment, and that are also of a more general nature. So the four that I want to discuss is bulk data, hacking, offensive and or defensive use, and predictability. So let's start off with bulk data. It goes without saying that the amount of data is immense. I mean, the production creates data lakes. It's growing tremendously on a daily and a second basis. And it holds a lot of historical data. Something a lot of people forget, data is almost always historical or real time, but there is no future data. that still always needs to be generated. And all this data is of incredible importance when dealing with potential and real threats to national security. The data as such are, of course, very valuable, but we're also faced with the famous needle in a haystack dilemma. If it's difficult to find a needle, then you want to be the needle in the haystack. And therefore, intelligence agencies actively seek access to bulk data sets for both reasons: the content of the data, but also as a way to trace needles. And several of these data sets are publicly available, basically commercially available. Because you should understand, generating new data is extremely expensive. So most of the data that we're talking about in the context of national security are existing data, are third-party data. And therefore, OSINT, open source intelligence, is an important cornerstone. And in this area, there are also a lot of commercial activities. There are highly sophisticated systems that offer access to hundreds of data sets in parallel, and that access can be sometimes quasi-real-time. So for the interception of real-time communications, which is one of the other, that's the other part of bulk data, very advanced systems are built and deployed. And collecting information that's traveling through fiber optic cables is not as easy as it seems. It's not like in the movies. It's really, really complicated. IP traffic and the market of IP traffic have their own dynamics. Effective and efficient data collecting and processing are actually only possible after substantial investments and preparations. And only intelligence agencies with sufficient critical mass can get involved in this kind of business. My second topic, hacking. Finding individual targets has become more and more challenging. Targets get educated and find ways to hide their data and location. And although the physical location might not change, cyber locations can change in a split of a second. For example, when a target moves from one server location to another server location. And if an authorization requires the location of a target, intelligence services might quickly lose a target when a different server location demands a new authorization. Terminal equipment has in this context become more and more an object of hacking. Smartphones, tablets, laptops contain a vast amount of data or provide access to cloud data, and we cannot do without. Or to quote the Supreme Court in the Riley case, cell phones, this was in 2014, by the way, so that's more than a decade ago. Cell phones, which are now such a pervasive and insistent part of daily life, are such a pervasive and insistent part of daily life that the proverbial visitor from Mars might conclude they were an important feature of human anatomy. And when I walk off a campus, I think that's basically true. I mean, it's an extension of your body, and everybody is looking. Yeah. We did that in Amsterdam 20 years ago. There was a difference between a tourist and an Amsterdam citizen, because Amsterdam was full with animal droppings. So it's not new to look down. The fact that data is in transit and it's encrypted makes mobile phones an interesting object for hacking. Sometimes the information is accessible in a decrypted way because it's decrypted on the servers of the service providers. But mobile phones are nowadays the real place to be. Special tools are developed by intelligence agencies, but are also commercially available to hack phones. Once you're in, you not only get capabilities like listening into conversations and real-time data traffic, also all stored and device-generated information becomes available, like location data and address books. Be aware that hacking a phone is not always aimed at the target, but it might as well involve those who can offer access to a target. NGOs and newspapers discovered that one of the available commercial tools, Pegasus, a tool made by an Israeli company, the NSO Group, was used to get access to phones of journalists and political opponents without democratic safeguards being in place. This scandal led to a very extensive investigation by the European Parliament. Defensive and/or offensive use. In literature and regulation, a distinction is made between defensive and offensive use. In traditional warfare, you defend your country and its interest against outside threats. When being offensive, you attack another state. But cyber activities are not that black and white. Obviously, you have to protect national security interests by defending against state actors with offensive cyber strategies. And countries like Russia, China, North Korea, and Iran are often mentioned as countries with such offensive cyber strategies. Attempts to hack into the systems of companies to steal business secrets are a common practice, as are attacks on vital and critical infrastructure. Destabilizing states by undermining trust in its institutions through misinformation is another example of an offensive strategy. And defending against all these types of attacks is a logical response. And let me also say that it's not always the states themselves, because often in law, in the context of national security, it is said that actions are allowed against states, but then you prefer not to be a state. So this is where all these famous advanced persistent threat groups come in, the famous APTs like Cozy Bear and like the Lazarus Group, who are fronting for states, who are often allowed to be active in a state. They also do all kinds of other stuff. It's also a business model. But these groups are also very active in the domain of misinformation and other activities I just mentioned. Demarcation lines become blurred once we go into gray areas, such as the preparation against offensive attacks by taking precautionary measures, or when setting and respecting limitations to explorative activities. The preparation against offensive attacks could include finding access to systems of known attackers, allowing the creation of new backdoors and planting traps, which can be activated when hostile activities take place. And what to do if hacking a state with an offensive strategy brings in more than expected. Once in, you might find information that was gathered from other states, maybe even from other intelligence agencies, or you may discover new ways to retrieve information relevant for national security. Should such opportunities remain unexplored if they aren't the object of the originally envisaged interference, the originally given warrant or authorization? My last point, predictability. Cyber is a fast-moving domain with a lot of unknowns. New technologies are quickly implemented, making existing tools obsolete or ineffective. Targets move around and quickly change their strategies. This impacts the predictability of actions and outcomes. Static regulation and traditional authorizations are based on the assumption that all relevant aspects can be considered when regulation is put into place and when warrants or authorizations are being granted. Intelligence agencies want more flexibility, fewer restrictions, more tools to be effective, and they claim that otherwise threats cannot be dealt with. But what is the impact of these kind of examples and developments on fundamental rights? As a European, I attach great value to the fundamental rights as enshrined in the European Convention of Human Rights and its EU version, the EU Charter of Fundamental Rights. Both provide a strong normative framework. Fundamental rights expressing free will, autonomy, and solidarity are in this context not limited to privacy, but also include freedom of expression and freedom of assembly, digital assembly, for example. Limitations to these rights are exceptions and need a strong motivation. And to stick with the European Convention on Human Rights, national security is one of the few allowed exceptions foreseen in the Convention. This makes national security special and explains why national security activities are not treated the same way as regular government or private activities. On the one hand, national security allows a higher level of interference. On the other hand, it needs to remain an exception with a high burden of proof. National security cannot, and I re-emphasize, national security cannot be used as an excuse for less protection and unfettered government interference. The jurisprudence of the Court of Human Rights, with its doctrine of the Convention being a living instrument, has confirmed this over and over again. But it does create a big dilemma. To deal effectively with these challenges, accepting more uncertainty and allowing for more flexibility is inevitable. But how to address these needs? Should we just throw out fundamental rights and allow intelligence gathering with fewer limitations and more invasive instruments? In my view, a change in thinking is necessary and a better system of checks and balances should be put into place. This can be achieved by defining a clear normative framework and by shifting the focus of oversight more from ex ante, where there is the assumption that everything is predictable and you can know everything by forehand, or ex post. Ex post oversight is writing reports and doing reviews, to ex nunc, real-time oversight, where you're aware of what's happening, where you can intervene to offer guidance, but also to correct and end unwanted or illegal activities when they take place. And this brings me to the example of a thing I worked on in the last few years, a change in the legislation of the Netherlands. Well, let me give you first some background. The Dutch intelligence legislation already allowed for bulk interception from satellite communications. So it was proposed to make that provision technology neutral and also to include cables. And when this was done, it caused a public outcry resulting in a national referendum. This was in 2018. And maybe a nice little side thing, the referendum was strongly supported and accelerated by the Dutch version of Last Week Tonight with John Oliver. I think there must be people who watch that show on a weekly basis. I do. This guy was really able to create momentum for the referendum. And a majority of the voters decided against the existing national security law. Not the provisions on bulk, but the entire law. So government reacted and said, well, we are going to soften some of the applications of the law, and we will start the process of a total review to come to a new intelligence law in due time. But in the meantime, it also became clear that the intelligence services themselves wanted different legislation that would allow them to deal with these new cyber threats. And in particular, the countries that were adopting this aggressive cyber strategy. And as the process for the new law was not moving forward, it's a lawmaking process, so I don't even know whether that ever moves forward in a way that we, as normal citizens, are used to experience. But it became necessary to come up with a temporary change of the existing framework. And for me and others, it was clear that even such a temporary change needed to include a proper system of checks and balances. Originally, this was not something that was supported by the services nor by the government. And cutting a long story short, the outcome, a change to the law that entered into force last year, does include a new way of dealing with cyber challenges by creating, on the one hand, more flexibility for the services, while at the same time substantially improving protection of fundamental rights. And it does so by introducing real-time and binding oversight. And let me give you a few highlights. Start with bulk interception. Bulk interception is split into two processes, a discovery phase and the actual interception. In the discovery phase, a broader set of data can be explored to determine a more focused interception. It creates more flexibility while at the same time increasing the level of protection against too broad interception. And the data that are gathered in the discovery phase cannot be used in the intelligence process, they have to be deleted. So you cannot use the discovery process as a way to get more data in. No, it's only meant to better define what should be the actual topic of the intervention. The necessity to keep and use bulk data sets needs to be reassessed on a yearly basis no later than 18 months after the acquisition of a bulk data set, and requires A, a new approval by the minister, and B, oversight has the power to decide that keeping the bulk data set lacks necessity. And such a decision by oversight implies that the bulk data set in question must be destroyed. In the case of countries with an aggressive cyber strategy, the burden of proof for authorizations is restricted to what is realistically foreseeable. So not what theoretically could happen, but what is realistically foreseeable. This is then counterbalanced by the introduction of real-time oversight and binding powers to end the execution of an authorization and to remove and destroy collected data. And all the binding decisions by oversight can be challenged in court. The highest administrative court is competent to hear cases, and the court procedures and decisions are public except for classified information. And this is an important shift, because normally you will see the opposite in legislation. You will see that everything that relates to national security is subject to secret court procedures and secret court decisions. And sometimes something might become public. The system is actually, this was also what was originally proposed, and we really fought that, and now we have, let's say, the normal way to deal with courts. Courts are public, but if it's confidential, classified information, that can be restricted. Probably that will still lead to documents with a lot of black pages, but you know there is a case, you know there is a decision, and it will be up to the courts to say something about what they have actually decided. And I think that that will very much help in avoiding conspiracy ideas and thinking there is a dark state or whatever. It makes things much more transparent than before. These and other modifications improve, again, the system of checks and balances. It contributes to more flexibility and certainty necessary to protect the interests of national security and to protect fundamental rights. A thing I also should mention is the court needs to take the decisions in a very, very short period of time. So this is not like a court case that can go on for months or years. It has to start within a few days. It has to be finished in, I think, 2 weeks. So very quick decision making. At the same time, the new framework is not all-inclusive and fragmented. Still, 2 separate oversight bodies are involved, one of them for the authorizations when required, and one for the oversight and enforcement. And fortunately, the new legislation does give more possibilities to exchange information between the 2 oversight bodies, but still. In the case of bulk collectioning, bulk data sets gathered or accessed via informants or open source intelligence are not covered, and binding oversight only kicks in when an extension of the initial term is needed. And as to hacking, the system is limited to activities of countries with an aggressive cyber strategy. And it's now, we have not had cases yet, but it's now up to the stakeholders to see whether the system is going to work. I'm very positive about it. And hopefully it will contribute to the overall review of the law, which, like I said, started in 2018. We still have no proposal. Besides some skepticism about the content of such a proposal, it's unlikely that a new law will enter into force before 2028. So this is a 10-year lawmaking process. It's very long. Allow me a few remarks about what I call professional independent oversight. In my view, professional intelligence services are entitled to professional oversight. Real-time oversight and binding powers are not to be treated lightly and are fundamentally different from a situation where oversight is merely ex post and non-binding. High standards for independence and professionalism need to be met if oversight wants to be really meaningful and effective. Professional independent oversight is nothing new, by the way. We know it. It is well established in other domains like financial markets, competition, communications. And the oversight bodies in these domains are equipped with a toolkit containing tools such as authorizations, full access to information. They can impose sanctions, such as cease and desist orders, and they can reverse and annul the effects of infringements. And allow me to elaborate on some of what I consider the most important elements of this, what I call professional independent oversight. There's, of course, the independence. That's reflected in various ways. It starts with the procedure for the appointment and resignation of the members of an authority exercising oversight. How transparent is this procedure, and how balanced are the nomination procedures and the nominations themselves? Given the fact that oversight and national security addresses the actions of government, political preferences must be as limited as possible. Independence also means organizational and financial independence. The oversight body needs to have budgetary autonomy and needs to be able to hire its own staff. Stability and continuity demand multi-year safeguards. And I already mentioned the famous toolkit. An adequate toolkit is essential. We have seen that in the early days of their oversight, such a toolkit was lacking. Most of the better established oversight bodies needed decades to get to where they are. A good example in recent history are the European privacy oversight bodies who, with the introduction of the GDPR, for the first time got access to a more elaborated toolkit. And there are all kinds of opinions about how they deal with this toolkit. So when I say it takes a lot to be able to deal with such an improved toolkit, then that's something you have to take seriously. I too often heard and still hear the argument that oversight in national security only needs the power of persuasion. Mind those words, power of persuasion. This is nonsense. First of all, the point of power of persuasion is primarily made by those who don't have binding powers or by those who don't want you to have it. Nor do I have any example of oversight that wants to get rid of its binding powers, because the power of persuasion is the strongest tool you can have, as some have once told me. And that was not at drinks at midnight. That was really like a serious argument. For me, it's exactly the opposite. Power of persuasion only works when you have binding powers. It's a simple stick and carrot issue. And as mentioned, binding powers need to be meaningful and effective and therefore allow for real-time intervention. My next point, transparency. It goes without saying that oversight needs to have full access to information. Oversight bodies should therefore be connected to existing information systems and be allowed to access information without prior consent or only on request. Obviously, the more delicate information is, the more safeguards need to be put in place. For example, the disclosure of the names of agents and informants or highly classified information requires appropriate procedures. A thing I wanted to highlight is some of you have maybe heard of it, the famous third-party rule. It's said that the third-party rule can restrict the access to national security information. The third-party rule is basically a horizontal limitation where one intelligence agency shares information with another intelligence agency under the condition that the receiving agency doesn't share that information with third parties. In my view, the third-party rule doesn't apply to oversight. First of all, a bilateral agreement cannot set aside a legal obligation. And secondly, oversight is an integral part of a system of checks and balances. It's therefore not a third party. Professionalism. Oversight is not an art. It's not a science. It's a craft. It's really something that you do with your hands and that requires specific capabilities. At least two things are at stake here: the organizational structure and the staffing of an oversight body. The organization needs to meet the needs for meaningful and effective oversight. Oversight is an independent activity, and the organizational structure should not mirror a governmental organization, but, for example, fit the working practices of the organization that you're overseeing. A result-driven approach is equally important. Compliance with regulation is not a goal in itself, but a means to safeguard the underlying normative framework. And this is what you also see with established oversight bodies. They have, for example, incorporated a risk-harm approach. They apply systemic oversight, and they aim at the balance between short-term and long-term effects and changes. But what's actually the status quo of oversight if you look at Europe? Well, it's complicated. Does it mirror the professional oversight that I've mentioned in, for example, financial markets or in competition or in communications? We still have a long way to go. As part of the Pegasus investigation, the European Parliament asked the European Fundamental Rights Agency, the FRA, to update an earlier study on oversight and national security. The study showed that out of 27 member states, only 17 have some kind of independent oversight. But none of them meet all the criteria of professional independent oversight that I just have mentioned. None of the 27. In several countries, only some type of parliamentary oversight exists or is considered to be the most important part of oversight. Of course, parliamentary oversight is important, but it's political oversight. It's not independent oversight, nor does it meet the criteria that I just laid out on professional oversight. So as an outcome of the Pegasus investigation, the European Parliament adopted extensive recommendations which were supported by a very, very broad majority in Parliament, because the countries that were part of this investigation varied from countries where, to keep it very simple, government was right, opposition was left, to countries where government was left and opposition was right. So there was a really big majority in Parliament that supported these recommendations, and several of them deal with independent oversight. Parliament made clear that independent oversight is absolutely necessary. It needs to have binding powers, and also Parliament made several references to Convention 108 Plus of the Council of Europe. This convention is an updated version of their Privacy Convention, and it incorporates the jurisprudence of the European Court of Human Rights. And that also means it incorporates the jurisprudence of the Court on National Security. And when entering into force, probably somewhere at the end of this year, it will be the first international instrument explicitly addressing data processing in the context of national security. The convention obliges states, and in this case, the convention is not only open to European states, but also states from elsewhere can participate. That this does happen with conventions of the Council of Europe from time to time. For example, the famous Cybercrime Treaty is one of those treaties where there is a similar situation, and where, for example, the United States have signed the convention and participate in the convention. The convention obliges states to have independent oversight, and in line with the jurisprudence of the court, it strongly limits the possibility of making exceptions based on national security. Exceptions are only allowed, I quote, to the extent that it constitutes a necessary and proportionate measure in a democratic society. Furthermore, oversight should also cover trans-border activities, and oversight bodies should also be allowed to cooperate. Oversight bodies should also be consulted on regulatory processes, and oversight bodies have a role to play when it comes to public awareness. I think this is a very important last obligation, because oversight bodies can see everything, they are independent, and they can tremendously contribute to trust in society when they do their tasks properly. Let me conclude. Professional independent oversight is not the solution to all problems. It needs to be complemented with high levels of internal oversight. I see it as an important role of independent oversight to safeguard and contribute to such internal oversight. And like I said before, nor is independent oversight an alternative to parliamentary oversight. Again, parliamentary oversight focuses on political responsibilities, whereas independent oversight aims at maintaining the rule of law by contributing to a proper balance between effective protection of national security and safeguarding fundamental rights. And the judiciary has to play its own role in this game. But when we provide a strong principle-based framework and the right toolkits, professional independent oversight can make a real difference to meet these challenges that we have, not only in the cyber domain, but who were a very big trigger to think of different types of oversight, but also more in a general way. Thank you so much for your attention.
So just looking around the room, I see our students from our cyber group. I see students who are doing international relations and are interested in European politics. And so although this doesn't relate directly to your talk, I always want to ask the question, what should our students be reading? What should they be paying attention to if they're interested in a career, either in intelligence or in oversight and accountability for intelligence?
This is on.
You can use mine.
Or should I? Okay, okay. You're actually asking, why did I leave academia and why did I go into, why did I take this position? Well, one of the most problematic things with national security is the only way to really get access to what happens is by getting in. So a lot of the material that is available is either written from the outside in, or sometimes you have to do pravda reading. You have to read between the lines. My speech has some between the line reading in it. I personally think it's one of the most important sources for information are the decisions by the European Court of Human Rights. They have a long tradition to deal with the topic. It's very balanced. You do have one of the biggest traps with the jurisprudence of the Court of Human Rights is that you only read their cases on national security, but you have to understand how the court in Strasbourg works. And so if you read a decision of the court in Strasbourg, you start with the dissenting opinions. Because in dissenting opinions, you can find what really were the concerns of some of the court members and where future decisions might be going. And you have to understand the broad essence of how the court in Strasbourg works. I mentioned one of the very important elements, that's the fact that the court uses the European Convention of Human Rights as a living instrument. They reinterpret the convention to include changes in society. This is Berkeley. This is a little bit like responsive law, Nonet and Selznick, that kind of stuff. Fundamental rights are fundamental rights, but you have to reinterpret them, and it's not like it's a founding father thing. People live, rules live. So that's what I always felt was very helpful to do. Is there other literature? Yeah, there are, but it's mostly historians who write about intelligence services. And these are really interesting books to read because they are funny. But I think there are too many historical studies. If you want to know what happens particularly in cyber, then you should think more in dual use. What happens within large tech companies is also the kind of stuff that is interesting for intelligence agency because you want to find a target. You want to find a specific group that's done for commercial purposes by tech companies, but it's done in the public interest by intelligence services.
In fact, that's exactly where I want to go, is the issue of dual use. And I wanted to invite you to go a degree deeper into the dual use issue. You talked about, oh, is that on? Okay. Oh, it's not working. Okay, great. So you mentioned Pegasus in particular. How do you see, what developments do you see in offensive hacking tools and the emerging marketplace for such tools? I mean, I just find it fascinating that so many of these tools are actually coming out of the private sector and then sold quite broadly by some vendors.
Yeah, it's Well, it's known that, for example, a country like Israel has a very high potential when it comes to developing these kind of tools. And many of the companies involved are actually run or have quite a substantial part of their staff coming from national security, which is obvious. The same happens with intelligence agencies contracting white hat hackers, because although the wages are very low, for a hacker, an intelligence service is an incredible challenge, because I'm not going to say all limits are off, because you have to comply with all the rules, but the tools can be used in a more broader way than you can do in a commercial environment. And then when later on you go back to a commercial environment, then of course the skills are still there. You can use those skills, and vice versa. I mean, a lot of the people that are being hired to do this kind of cyber work are people who have experience in a commercial environment. It's actually one of the very few examples that I know where there's interaction between private and public, because often in government that doesn't happen so often. There's also a lot of dual, and I mentioned one of the big examples of dual use. Those are the data sets that are being collected by, once again, the famous group of companies that is also under permanent attention by the FTC, data brokers.
Yes, yeah.
So what a lot of people don't know, and this is public information. You go to, I believe one of the tools is called Maltego.
Maltego. Yes, great.
It's an open source tool, yeah. But around it there are applications. Around it there are data sets, and those data sets include, for example, the location data that have been retrieved via advertising on mobile phones. So everyone who has a mobile phone allows one or more services to get full access to the mobile phone. That's almost a certainty. All that data is, depending on how it's being processed, is real-time or near real-time data when it comes to location data. That's highly valuable information. To get access to that information from a national security perspective, often, if they would do it on their own, requires a warrant. But by contracting, by having a commercial contract with these kind of providers, you get access to similar information. That's why real-time oversight should not be limited to things that are subjected to authorizations. I also prefer to use the word authorizations, because the word warrant is criminal law oriented. This is not the case in intelligence services. That's public affairs oriented, more or less, administrative law oriented. So to cover everything, you need to have, and to find a good balance, because the amount of information you can access is enormous. The amount of tools is enormous. Of course, like I said, developing the tools by yourself is extremely expensive. And it's fiction to imagine that an individual intelligence service is able to create the same capabilities as Google or Facebook. So that's also why you have international cooperation. That's why you have dual use of tools that were not originally meant for national security, but are also very apt for national security purposes. It's a question of writing the right application upon the basic layer of the product.
I know we have a lot of questions racking up, but I do want to press you on one more. When we invited you to give this talk, it was before the election. And a lot of things have changed. So in this country, we have President Trump, you have Prime Minister Wilders.
No. He's not Prime Minister. Our Prime Minister is the former head of the National Intelligence Agency.
Oh, okay. So I'm tracking that. The question I have is, what types of assumptions are changing? What is, if you were still in your job, in this job, what type of base assumptions that change? What types of practices might change as a result of such an important difference in style of governance? I mean, I'll just note, without politicizing too much, President Trump has an esoteric approach to intelligence where he has released raw intelligence where he's told adversary nations about sources. And this might shake some people's commitments to the field.
What is a standard procedure in Dutch legislation is that the intelligence agencies are obliged to have to report on important changes in the relationship with their counterpartners in other countries. That includes an analysis of the political situation and includes also analysis of what does that mean for the information sharing. And to give you a known example, when I think it was 70 years ago or something, the government in Austria changed and became a right-wing government where it was known that there were direct contacts with Russia. Western intelligence agencies stopped or limited the amount of information that they were sharing with the Austrian intelligence service. This is public information. This was in the newspaper, so that's what I can tell. So if a country, and what is very important is that you have always to keep in mind that in intelligence services there's a famous saying, quid pro quo. You get as much as you deliver. So if unilaterally a country says, I'm not giving you any more information, one of the effects, potential effects, is that the other countries are not giving you any information anymore. And if there is a risk that you don't oblige with this third-party rule, so if there's a risk that if country A has determined that country B is a hostile country, that you're not allowed, then of course it's not possible that information about country B is being shared, or the information being shared with country B. So this risk assessment is happening, I'm absolutely sure, in all countries around the world, and it will have direct effects on the information sharing between intelligence services. And that can be very critical information because there are known situations in history where particular countries were able to get a unique information position. And getting information positions is crucial. So if you don't have that information position relating to a particular country or a particular subject, it means that you basically get no information anymore. So yes, I can only assume that that as there was a serious impact, and as there have been statements about who are our friends and who are our foes, that this will definitely be taken into account. And don't be mistaken, the fact that European countries are sometimes very polite, seem to be lacking activity, doesn't mean that there is nothing happening. I think things are very unfortunate at the moment because I think cooperation is the most important thing you need in an international environment. But often those are, there are these midterm and long-term effects, and that's what you have to be really cautious about. That's also something we have seen, for example, with misinformation. It's a very, very complicated question. It's very close to freedom of expression. The problem is there are so many surreptitious methods that have midterm and long-term effect that it's a great challenge for intelligence agencies, as also this kind of disinformation is more and more linked to, for example, political parties. And that's one of the most difficult tasks of intelligence agencies. That there is one known example, the German example, where one of the political parties, the ADF, is the subject of investigations by the intelligence services. Their system is such that this can become public, but it is an incredibly complicated question, what to do with threats that come from inside your country, inside your own national system. And that's where also independent oversight can be an important contributor, because intelligence agencies are part of government. So government takes a decision on what the priorities are of an intelligence service. It's damn complicated for a government or a minister who has a particular political color to favor actions that might involve other political parties. And then it helps tremendously if in real time your independent oversight body is informed and has said, okay, we understand that you take these measures and you are going to take these steps. This is again where I was used to go to the intelligence services when they had new groups of people coming in, and then to discuss with them what oversight was, and everybody started with the idea that oversight was there to suppress, but oversight is not there to suppress. Oversight is not a law enforcement organization. Law enforcement people should be very careful when they enter into oversight, because they have been trained to do something completely different. Oversight means you're in dialogue with the ones that you oversee, and you try to maintain and to promote this balance between the needs of society for national security activities and the protection of fundamental rights, which is an incredibly difficult message, because, for example, if you live in a multicultural environment, in your country, there are many, many people who have always experienced intelligence services as oppressors and as organizations who have been involved in extreme wrongdoing. And it would be naive to say that things are beautiful in countries like Scandinavian countries or the Netherlands. That's not the case. But the ideas about national security and oversight are sometimes really extreme.
Any audience questions? I saw a couple hands earlier, and if not, yes, Frida, please.
Thanks so much. Is this on? I think so. Thanks so much for your interesting and timely remarks. A few weeks ago, President Trump fired 3 Democratic members of the Privacy and Civil Liberties Oversight Board, which means they no longer meet a quorum to undertake some of the really important oversight duties that underpin the data privacy framework. I was wondering if you have a view on what that means for data transfers from the EU to the US and generally the data privacy framework.
Planes will continue to fly. Europeans will continue to have Facebook subscriptions, although the word subscription is not the real term. Well, there are a lot of presidential decrees involved here. The role of the PCOP in general data protection is limited. No PCLOP, because I don't know what's going to happen. I remember that in the past, for a very long time, there was no PCLOP because there were no new members, and it seems that in the statutes it says there need to be at least 3 members. So if 3 members get fired, basically the whole organization comes to a standstill. Like I said earlier, it will be taken into account. If there is a substantial change in the system of checks and balances, for example, if also the tribunal, I believe it's a tribunal, it's called a tribunal, will be annulled, then everything falls apart, basically. There's still a third Schrems decision that is coming up. I can only assume that the court will still have some critical remarks. If the political situation changes in the meantime, that they will take that into account too. And I know there is a lot of, Paul, I read your last article, we just discussed it. You also mentioned data localization. I know that there are advantages and disadvantages to data localization. But if you want to protect your citizens, if it's quite clear that there is an uncertain situation about what happens with their data, then I can understand that governments choose for data localization. Data localization is growing. It's a sign of states not trusting each other anymore. or the positive side, states being more and more aware of the fact that they need to protect their own citizens. And it's somewhere in between.
I mean, it's also technology. It's also the
Yeah.
problem of AI and the LLM models where everyone wants on-premises solutions.
Yeah.
And so I think we're going to see a lot more sovereignty. We have time for one, about probably one question. Please go ahead.
Thank you. And this has all been really interesting. I was wondering about the relationship between the European Court of Justice and the European Court of Human Rights. And I perceive very much from the outside that there is a power struggle between the two. And I was wondering if you could comment on that relationship, specifically when they're ruling on national security related issues, and if we could foresee in the future the European Court of Justice paying more dues to the European Court of Human Rights, in particular, if the European Court of Justice were to rule on, for instance, EU-US data flows, just what the role would be in that relationship.
Yeah. Thank you very much for asking this, because this is a very important topic. And the same question was asked to the former president of the European Court of Human Rights, Robert Spano. I know him very well. He's a great person. If you ever want to have someone speak, ask Robert Spano. And if it gets very late, ask him to sing. And Robert was very explicit about this topic. He said, it is just not, my words, paraphrasing him, it's just not true. There is not something like a divide between the court in Luxembourg and the court in Strasbourg. They see each other on a regular basis. They discuss their cases. The court in Luxembourg quotes Strasbourg jurisprudence and vice versa. It seems there are people who think it is absolutely necessary to find differences between the two courts. But for example, by nature, there are differences. This is different. This is also what Robert explained at a session. He said, the court in Strasbourg deals with specific cases. The court in Luxembourg deals with explaining the treaty. So it's more abstract. And you also know that in the European Charter of Fundamental Rights, there is a provision that deals with how the two relate to each other. And basically, this is Europe still building itself. I mean, it was only with the 99 Treaty of Maastricht, or you can take Lisbon, that Europe became more than a community of coal and steel. And that fundamental rights, that was with the, I think with the Lisbon Treaty in 1999, that the Charter of Fundamental Rights, the Charter of Fundamental Rights became a full part of the EU acquis. So the EU is incredibly young if you compare that with the United States. More than over 200 years history. Europe has a big history, but not the European Union, not unifying Europe. The Council of Europe preceded to some extent. The Council of Europe is broader. It has, I think, 47 member states now. But it's not very helpful to take as a point of departure that there should be a quarrel between the two courts. And people who think otherwise and who do a micro reading of decisions, they just don't get the bigger picture. Both courts are very committed to fundamental rights and to protecting fundamental rights. The court in Strasbourg has a more Anglo-Saxon tradition. It has concurring opinions, has dissenting opinions. The court in Luxembourg is more structured like, let's say, the French-German tradition of courts, where it is the unity of courts, so you don't have dissenting opinions. But the goals don't differ so much. And sometimes it's also a struggle to come to the right decision. So both courts also change their opinions sometimes when they get new information. This is where, for example, the court in Strasbourg made much more clearer, particularly also in the context of national security, that if states don't take their responsibility to offer citizens sufficient levels of protection, the court will have the possibility to intervene at a much higher level by saying what countries have to do. So it's a complex system. There are two courts, but we're all building to get a more coherent European system together. And this is also, you know, we quarrel a lot in Europe, but we all have seen Game of Thrones. And we know that the biggest threat is internal vanity, and the real threat comes from the outside. And that has become much more clearer in the last few weeks. So there's an interesting development going on in Europe at this moment. And I'm the first generation who was educated about European law. I did my traineeship as a student with the Council of Europe, Human Rights Department. I'm really convinced that we can get there, but don't think it's happening overnight.
It occurs to me in listening to your narrative that we should have invited you here to give at least 2 and maybe 3 talks, because our students and faculty here want to engage you on a number of issues ranging from data protection to AI to intelligence and to intelligence oversight. We're out of time, so we can't have those conversations. And leaving on the table are a whole bunch of issues I wanted to talk about, such as NATO, such as Russia, the driving corruption that I think we're beginning to see, how, you know, the game theory of intelligence agencies that don't have great capabilities, whether there can be effective intelligence oversight in a weakened democracy. These are all the questions that I was hoping we could get to today. The good news is that we have a reception and Professor Van Eijk is staying. So we can have these conversations in small groups. Thank you, Professor Van Eijk.